Florida Foreclosure Defense Attorney Richard Shuster, and today's topic is, what does a homeowner need to know about service of process in a foreclosure case? I want to tell you about a case that we were hired to defend where the homeowner, who had $1 million home and a mortgage for a lot more than $1 million, came and hired our firm after interviewing 4 other firms. The homeowner had a lawsuit that was filed against them in January, and they weren't served with process until June. 4 other law firms who they met with didn't realize that the bank had blown the statute for service of process. Once a lawsuit is filed under Florida Rule of Civil Procedure 1.070J, the bank's going to have 120 days to serve the homeowner. That means that between the time the lawsuit's filed and the time that a process server puts a copy of that lawsuit in the homeowner's hands, they got to get that done within 120 days. We filed a motion to dismiss that case based on the failure to serve within 120 days. It was something that none of the other lawyers who that homeowner interviewed with spotted that issue, and that motion was granted. The bank's case was dismissed, and we became entitled to recover attorney's fees on behalf of that homeowner from the bank, such that the fee recovery will pay for almost all of the homeowner's legal expenses. If you have a foreclosure case and you haven't been served within 120 days of the date the lawsuit was filed, your case should have a motion to dismiss filed, and unless you were actively dodging service of process, if they blew that 120-day window, the case should be dismissed. In serving a homeowner, they have to do it with a process server. They need to serve that homeowner themselves. They can't just leave it on your doorstep, slide it under the door, or put it in your mailbox. They can't leave it with a small child or a babysitter. If you have questions about service of process and whether you were properly served, feel free to give us a call at 877-511-STAY or 321-622-5040. You can visit any of the firm's 3 offices in Miami, Fort Lauderdale, or in the Space Coast, or visit our website, www.attorneyforeclosuredefense.com, or just drop me an email at foreclosuredefenselaw@gmail.com. Is attempt to reopen lines of settlement communication. We've had a lot of files where initially the bank was reluctant to entertain any settlement offers, but on the eve of trial, faced with the possibility